I just want to welcome everybody here this evening. My name is Lisa Poff. I am the director of the Indiana Deafblind Services Project, and I am so pleased that you are here to be with us and hear Gordon talk about, let me think. Oh, suddenly my brain went blank, Gordon. Guardianship and ABLE accounts tonight. Yes. Anyway, I just had a couple quick things. I am recording this evening, and we do have captions on if you need to use those. If you have questions, if you would want to raise your hand in the Zoom app or type something in the chat, or Gordon, do you care with this small of a group if they just pop in and ask their question?
That'd be great.
Okay, so please feel free to ask questions as you need to. At the end of this, I will put something in the chat box about an evaluation. It's really helpful for me if you do fill that evaluation out. If you fill out the evaluation, you will also get a certificate giving you contact hours for attending this in case you need that for some reason. And it should be pretty self-explanatory. It'll just do it automatically for you. I think that's all, Gordon. I'm going to let you introduce yourself and get going.
So much, Lisa, for helping make this workshop series possible, and the Indiana Deafblind Project and all that it means for so many families and kids. So very thankful for your work. This evening, as Lisa indicated, we'll be focused on guardianship and ABLE accounts. They're both important topics, and I do invite questions. It breaks things up. It makes it more interesting. So please do not hesitate to unmute yourself and ask questions as we move through the subject matter. There are two PowerPoint presentations this evening, one on each topic, one on guardianship, one on ABLE accounts. And so we'll start with guardianship and then we'll move to ABLE. If you're primarily on board to hear one versus the other, neither are that particularly long. So hang in there with me. I think guardianship will probably take no more than a half hour. And then we'll move on to ABLE. ABLE accounts are a hot topic these days because of enhancements that have been made since the legislation was originally passed 10 years ago. There have been 2 updates already and a third pending in Congress right now. So there is much to talk about with ABLE, and we'll see if we can get to ABLE by 6:30 or shortly after. So please hang in there with us. There will hopefully be helpful information for everyone this evening. Also, I do want to mention that as a part of participating in any part of the Indiana Deafblind Project education series that we're doing, then you're eligible for a free follow-up consultation. By free, meaning it costs you absolutely nothing. And that can be done in person in our Indianapolis or Louisville offices, or it can be done virtually from the convenience of your office, home, etc. So you should receive an email from Jamie Sturkey, my parent advocate and relationship coordinator, thanking you for participating in the series, and getting a free consultation is as easy as responding to that email, indicating you'd like to schedule that. So again, thank you to everyone for participating this evening. If you know of any friends, family in the special needs community that would benefit from the information this evening, feel free to send them an email with the link to what we're going over. I would love for us to add one or maybe a couple of families by the time we're done this evening, and share that information with them so that they can join in as well. Again, everyone's encouraged to ask questions. We'll keep it simple, as Lisa has suggested, by simply unmuting, and then you can speak out and share your question with all of us, and I'll be happy to provide helpful information. By way of full disclosure, I am a governor-appointed member of the ABLE board, so I do help oversee the ABLE program for the state of Indiana. By way of introduction, I'm a certified financial planner. I have been in practice for over 40 years. My practice focuses almost exclusively on special needs. So all day, every day, I'm meeting with families to focus on the legal, financial, and government benefit issues that accompany the special needs journey. And a big part of my practice is providing a helpful education. So if you know of any other parent groups or perhaps church special needs ministries or school groups or that type of thing where education along the lines of what we're covering during this series would be helpful, then please let us know. There's never a charge for me to either come and speak or virtually speak to a parent or family group, and I love sharing with families, helping people wrestle with these challenging topics and issues. With that said, we're going to move to guardianship first, and I will bring up that respective PowerPoint presentation. So hang in there with me. Let's see here. All right. Okay, let's see. Okay, and boom. And let's do this. We'll come back here. We've got to hit the share button. Okay, so if my experience proves me correct, the guardianship PowerPoint should be on your screen. If anyone is not seeing it, then please unmute yourself and let us hear from you. If I don't hear anything, I'll assume everyone has the guardianship up. It indicates that I'm sharing, so hopefully this is working. Okay, we are not all things to all people. We do work with literally thousands of families throughout Indiana and Kentucky on the legal, financial, and government benefit issues involved with the special needs journey. And despite the depth of our knowledge and the breadth of help that we provide statewide, we're not all things to all people. We will be talking about what is guardianship, terms to know, some information on state law, type of guardianship, appointing a guardian, liability of a guardian. I get those questions frequently. So if I'm the guardian, does that mean I'm responsible for every act the child does? This type of thing. So we'll talk about that. Removal and termination of a guardian, and it does happen from time to time that someone needs to be released from the guardianship responsibility, and then alternatives to guardianship. So a loaded agenda, and we'll move right on through. So what is guardianship? It's a legal relationship between a capable adult and known as the guardian, and a ward, the protected person, the person for whom guardianship has been obtained. In most states, laws presume that individuals over age 18 can make their own decisions about what is best for them in their daily lives. Some may feel it is necessary to apply for guardianship to protect their loved one with special needs. So protected person is an individual for whom guardianship is sought. The petitioner is the person who's filing with the court and initiating the guardianship process. Respondent is the person for whom guardianship is sought, and so forth. So there are a variety of terms, as you can see, with guardianship and with special needs. Okay. Guardianship depends upon state laws, regulations, and practice. Guardianship advice should be state specific. Seek legal counsel to get state specific information. Now, what's interesting is that, as you can see in the last bullet point, prior to, or this is an example, prior to 2018, so literally right before COVID hit in early 2020, Kentucky was the only state to require a jury trial when making a disability determination in a guardianship proceeding. So believe it or not, prior to calendar year 2018, if you wanted to secure guardianship for your child with special needs, you not only had to go to court, but a jury was impaneled to hear the guardianship case and were permitted to ask questions and probe about the situation as a part of the guardianship hearing. It was unnerving, to say the least, and we were so blessed that the legislature in Frankfurt was able to pass legislation in 2018. Little did we know that a year and a half later, COVID would hit, and guardianships would have been all but impossible. How are you going to impanel jurors when no one can go anywhere? So that's an example of the nuances state by state. But since that time, a panel of jurors no longer has to be seated, provided that everyone or the parties are in agreement regarding the guardianship issue. If it is contested, then you have a different situation. All right. Is okay. So I'll go back. There we go. All right. So there are different types of guardianship. There is full guardianship, and full guardianship basically represents the individual pieces of guardianship put together. The two elements, the two most common elements of guardianship is guardian of the person and guardian of the estate. So having guardianship of your child with special needs at age 18 can be just oneself. So it's possible to have guardianship guardianship for the person, but without the guardianship extending to finances. So this is what we call partial guardianship, limited guardianship, or otherwise known as guardianship of the person. So with that, your guardian, you oversee their physical presence, where they are at, what they are doing, their medical issues, etc., but you do not have authority over their finances. Then there is a second type of guardianship known as guardianship of the estate, and it is basically what or everything that the guardianship of the person is not. So whereas guardian of the person puts you over everything that is personage, that type of thing, guardian of the estate puts you over their finances. And one can go to court and petition, in essence, petition the court for a hearing that focuses on full guardianship, full meaning guardianship of the person and guardianship of the estate. Or you can go to court with just a request to get the guardianship of the person, or specifically guardian of the estate. So you can have partial or you can have full guardianship. As far as joint is concerned, at the far right, more than one individual sharing guardianship authority. So the process on the right, the joint process, is designed to make people aware that it's possible to have more than one person on the guardianship case. So joint would typically be the two biological parents, a biological parent and a step parent, adoptive parents, etc. There are a variety of combinations there, that type of thing. But typically when we say joint guardianship, we have a guardianship that reflects on more than one guardian. Now, courts are usually reticent to appoint or approve a guardianship by committee where you have 3 or 4 individuals attempting to serve as guardian simultaneously. So in almost all cases, it is no more than 2 people that serve as guardian at a particular point in time. For those individuals, we're bringing up here the possibilities or different arrangements that can be made. Okay, so required forms are filed. The petition is a combination of information provided by the parents, the attorney assisting, and it also then includes the physician or MD's report with the guardianship at the same time. And all of that is put together and then filed at the county court based on the county of residence, the city of residence, etc. So once that petition goes in, the court then will typically approve the petition. The court will appoint an attorney for the respondent to represent them, that is the 18-year-old or soon to be 18-year-old, throughout the process. And they will be the advocate for the child for whom guardianship is being obtained. The court will schedule a hearing date, typically within 60 days, and the court will the court will appoint, and it varies by county, and it varies by, in other words, where you're located, as to just how much infrastructure or how many people are going to be involved with the hearing or the guardianship decision. Let's see here. So, county attorneys can be a resource for families. As it indicates, county attorneys prosecutes the case to determine disability. So this is where you need a report from a physician, and it has to be an MD, not a social worker, master's degree, or PhD, but an MD. Has to sign off on the medical evidentiary to support guardianship and so forth. So all of this, again, is put together as a package and submitted to the county court. The objective of the submission is the scheduling of the guardianship hearing. So that's what you're seeking. You're asking, can't we schedule a time, is the objective. Let's see here. Okay, at least one member of the team will testify. So there are checks and balances, bottom line. In Indiana, a judge will hear the guardianship case. And again, there may be one or more individuals that the court puts in place to help oversee and participate in the process toward guardianship. Once the guardianship is granted, then the judge issues the order from the bench, and that makes up the guardianship papers that one will need to have going forward. Okay, so these are all a part of what goes in with the submission for the petition for guardianship hearing. Proof to the court that the person is not able to care for him or herself. The physician's certificate is required. All interested parties must be notified. And let's see here. The guardian's powers in dealing with the person's property are carefully restricted by law. So if there is property or assets, other issues, then let's see here. Yep. Okay. All right, liability of the guardian. We touched on this earlier. So liability of the guardian, a guardian must use reasonable care and caution when making decisions and doing things on behalf of the protected person. Unless a guardian acts negligently, unreasonably, or irresponsibly, a guardian is generally not personally liable for any of the actions taken on behalf of the protected person. So liability is not, you're not automatically an accomplice to anything and everything that they do. And so laws are protective of guardians in those situations. A guardian may be held liable for his or her actions where the protected person's property is damaged due to careless acts of the guardian. So common sense stuff. So removal of the guardian. A guardian may be removed by the court if they are not properly performing their duties. A successor guardian will be appointed. Okay, a successor guardian may also be appointed if the first guardian resigns or dies. All right, guardianship generally terminates. So this is where someone has guardianship and it terminates. So if one has obtained guardianship for a minor, as an example, it's indicating here that at age 18, the individual for whom the guardianship was obtained at age 18, a juvenile guardianship has to be updated or redone. And so people will want to be careful about going to court for guardianship much before the 18th birthday. If you're more than a month before the birthday, you're asking the court to grant guardianship for a minor. And while that can be done, once they turn age 18, they're emancipated, and that guardianship is no longer valid. So if guardianship is obtained prior to the age of 18, you may find yourself returning to court at age 18 to get the guardianship updated. All right. Person led, the protected person is no longer incapacitated, so they can be eligible for the full number of slots. Okay. In the case of a guardian of the property, the estate is exhausted or the estate is less than some statutory minimum, and that would cause guardianship to terminate, at least guardianship of the estate. And then the protected person's residence is changed to another state. The guardian has to be appointed in that state. So in other words, if your protected person, your ward, the person for whom guardianship is obtained, moves from one state to another, then in a matter of months, guardianship should be updated to reflect the new residence state. Okay, the alternatives to guardianship. There is a representative payee, that would be the person receiving their Social Security benefit each month, and that person can talk to Social Security. They do not have to be a guardian. On the other hand, being a guardian does not automatically make a person a representative payee. So this is specific to Social Security. Healthcare representatives, durable power of attorney, and then specific power of attorney, trust, protective life proceedings, and parental powers. So parental powers must be appointed guardians where, or parents must be appointed guardians where significant amounts of money, property, or other assets are involved. And that's guardian of the estate that we were talking about before. Okay, representative payee, we just touched on it. That's the person authorized by Social Security to receive, manage federal funds for a person who is unable to manage them on their own. If the only income is SSI or Social Security, separate records must be maintained, and see here, and the representative payee must not mix those funds with their own. So, so when guardianship is obtained, then typically where there are monies, they are held in a guardianship account, and it's not acceptable to have those funds in an account owned by the guardian. So the funds need to be segregated and kept separate. Periodic accounting may be required to the Social Security office. Regardless, it is important to continually maintain detailed records of all activity. Okay, so these are alternatives to guardianship. So they include representative payee, so someone being the representative payee on a Social Security benefit, healthcare representative, a person elected to make healthcare decisions where they are unable to, and durable power of attorney is next, and that's to assist with their finances. So there are mechanisms in place that can make guardianship unnecessary if the young person has capacity. That's really key, is having capacity or an understanding of what these things are. So if the 18 or 19 or 20-year-old that you might otherwise consider for guardianship could understand what a durable power of attorney is or a healthcare directive, then it may be possible to have, under those documents, assist this type of thing. Okay, it may include power to receive federal checks, handle bank accounts, buy and sell real estate, and make healthcare decisions. Okay, all right. All right, remains in effect during incapacity or disability, ends when the power is revoked or the individual with special needs passes away. Designed to manage a specific asset, and usually an account or deposit of a bank or similar institution. And while competent, the owner may use forms provided by the institution, preferable to a joint account which credits ownership and interest for the individual being asked to manage the account. So different considerations, specific powers, but these documents, the healthcare representative, especially in the durable power of attorney, are alternatives to guardianship. So if the child with special needs is able to understand certain issues, then if they have the capacity to understand these issues or these documents, then it's possible for them to sign the documents, and that's an alternative to guardianship. Okay, special needs trusts. Someone serving as the trustee of a special needs trust is another example of having others involved, so everything does not rest with the individual with special needs. Generally, a special needs trust, the trust beneficiary cannot be the trustee anyway. So certainly a part of special needs planning is to kind of look over family human resources for who can do what, etc. Okay, let's see here. All right, protected proceedings. Okay, the court on request and without appointment of a guardian may issue a protective order. Sometimes these are temporary, that type of thing. So not all families are suitable to take advantage of guardianship. The situation varies, but we need to look at what the capacity situation is, because if they're not able to understand a durable power of attorney or a healthcare representative form, then guardianship may be indicated, because if they're unable to be in charge or direct their affairs, someone needs to. Okay, once you obtain guardianship, it depends upon where you're located. The Indiana state statute allows for counties to request a biannual report on the individual in order to maintain the guardianship. But again, the enforcement of that varies by county. All right. Let's see, parents of a minor, jointly or as survivor, may execute on behalf of the minor consents waivers or power of attorney under the Internal Revenue Code and according to state tax, etc. Okay, so we're at about the end of guardianship, and we're right on track at about a half hour. So I see a question in chat, and the question is, let's see here. Is it easier to get guardianship? Okay. Is it easier to get guardianship if the child is on the Medicaid waiver? And it certainly does not hurt. So if you're applying for SSI because of a developmental delay or some amount of diminished capacity, and if they have the family supports waiver, which is the waiver that speaks to developmental delay or some amount of reduced capacity, then those would be indicators that guardianship should be considered. What a great question. Then also generally with the new supported decision making, it's harder to get guardianship, harder to prove. Really a big key with the guardianship petition is having the doctor sign off, confirming diagnosis and the appropriateness of guardianship. Getting that piece in place is a big part regarding moving forward with guardianship. Okay, all right, here we go. All right. Okay, so that is guardianship.
Mr. Holmes, I had a quick question, if you don't mind.
Okay, thank you. Let's see. Okay, we've got a couple of things. Okay, one is, did I miss something on trusts? Um, well, trusts are not the primary topic this evening. However, we will certainly have the opportunity to talk some about trusts during our discussion of ABLE accounts because it's difficult to talk ABLE without also talking special needs trust. What are the similarities? What are the differences, etc. So I think it's Benji that is asking. And so Benji, hang in there with us, please, and we'll work to incorporate some information on trust as a part of the discussion on guardianship, especially since we're right on track with the half hour for guardianship. Next up is from Angie Burton. And hi, Angie. I'm delighted that you're with us this evening. What happens if there is no backup guardian? If something happens to me, if I'm guardian, what is generally the process in Indiana? Is there an order of people? What if no family is available? What usually happens? Okay, so if they are a minor, they would probably go, the court would place them in a foster care situation or a supported living environment. The court can appoint if they are 18 or over, the court can appoint a professional guardian that the court will pay for. And that's typically if there's no one that's stepping up or willing to serve. Otherwise, the court would look for family to figure out who in the family hierarchy is willing or able to serve as guardian. So there's a bit of a process of elimination, but ultimately it's family, a close friend, someone willing to serve that can put forth why they qualify. And then beyond that, it would be the them being placed in foster care if a minor, or if an adult 18 or over, the court can appoint a professional guardian to look after them. It's interesting that this comes up this evening because I just had a meeting this morning where I was meeting with the parents of a child with special needs. And during the meeting about the child with special needs, the issue of the parent's brother came up. And the brother is age 62, but is in a situation of special needs, unable to function, unable to take care of their affairs. So the question is, what can you do? And we discussed everything from the social worker in the hospital to the county attorney to adult protective services and emergency hearing. There are a variety of levers that kick in situations where there doesn't seem to be anyone to advocate for or involved. Okay, excellent questions. Thank you so much. Appreciate it. And we're going to move on to ABLE accounts. So let me bring up the presentation for that. And I appreciate the questions. Thank you all. Okay, thank you all so much. Okay, this actually should already be up. There we are. Excellent. Okay, so I think I need to reshare. Let me double check this. Thank you for your patience. Okay, my experience tells me that I am now sharing, and this should be on your screen about ABLE accounts. If for some reason the ABLE account slide presentation or a PowerPoint presentation, excuse me, is not on the screen, please unmute yourself and let me know. Okay, so ABLE accounts have their beginning going back before 2014. And technically, the act was renamed the Stephen Beck Jr. Act because this gentleman in the state of Virginia championed the cause of ABLE for 7 long years. And Stephen had a daughter with Down syndrome. And while he understood about 529 accounts and how they could help children save for education purposes, his daughter with Down syndrome was not looking at post-secondary education, and therefore he wanted to know what's available for her. So after 7 long years of meeting with people and advancing the ideas of this, an ABLE account was started. And so it was patterned after the legislation that brought about 529 accounts, and ABLE stands for Achieving a Better Life Experience. ABLE for short, Achieving a Better Life Experience. So again, came about at the end of 2014, and the law allows eligible individuals with a disability to have a tax-free savings account modeled after the 529 college savings accounts. Legislation has been passed in most states, so most all states have an ABLE account. And then in 2017, just a few years later, the Tax Cut and Jobs Act of 2017 was passed, and that brought enhancements to ABLE accounts. Okay, some points to be made on ABLE accounts. One must be blind or disabled prior to the age of 46 as of 2026. So through December 31st of this year, 2025, it is age 26. So next year, we are looking for the age of eligibility for ABLE accounts to go from 26 to 46. What does that mean? It means that if their disability originated prior to the age of 46, then they are eligible for, they're eligible to participate in an ABLE account. So currently it's 26, so it's for the younger set, but effective with January 1st, 2016, it's going to be anyone whose disability originates prior to age 26. So 26 is going to go to 46. That's going to open up the eligibility for ABLE accounts. Okay, so in addition to being in the right age group, and currently for the moment under the age of 26, again, as of January 1st of next year, age 46, one needs to, for ABLE accounts, needs to either have SSI, be applying for SSI, or anticipate at some point in the future applying for SSI. So ABLE accounts look for Social Security to make the determination of disability. Okay, maximum annual contributions. For last year, it was 18,000. And just a few weeks ago for 2025, it came in at 19,000. So that's very, very cool that the maximum amount continues to increase. And it really has gone up over the years. All right, so again, 18,000 was last year's limit. This year is 19,000. So there are also provisions for rollovers, so you can roll over money from one ABLE account to another. And then also, believe it or not, you can transfer money out of a 529 college account to an ABLE account. And that is gaining a lot of steam, because if ABLE accounts are in place where, let's see here. Yeah. All right. So so there are different avenues and options with this. So with an ABLE account, you actually can set up the account and just contribute cash or monies to the account to get it up and going. You can put in money systematically, so much per month. You can fund it with a lump sum. These ABLE accounts are typically set up online. They only take a half hour to establish, so they're not difficult. It's funded by listing an account number and a routing number for the bank account that holds the money that you want to utilize in funding the Special Needs Trust, or excuse me, in funding the ABLE account. So as a part of the application process for the ABLE account, you'll enter a routing number and account number and set up an electronic debit or transfer from the ABLE account or from the checking account over to the 520 over to the ABLE account. We'll get it right. So with the routing number and account number into your ABLE account application, then you can request, $250, $500, $1,000, whatever amount you want transferred over from the checking account or savings account with the respective bank or credit union over to the ABLE account that you've established. Transfer of certain retirement accounts may be possible. So what this is individuals with special needs are at a record number in the workplace. And so they're earning funds, and in some cases, they're participating in 401ks. Well, a 401k balance is considered an available resource if they're no longer employed there. So let's say that they had accumulated $5,000 in a retirement account at work. Then if they terminated from that employer, they could cash out that 401k, transfer it to an ABLE account, and that benefit would not count against them. So, ABLE accounts are helping on multiple fronts. Among those, maintaining eligibility for Medicaid and Medicaid waiver services, SSI, etc., by being a convenient place for funds that would otherwise get them in trouble can be deposited. Okay. See here. So qualified retirement savings contribution may be eligible if filing taxes due to earned income. So that's another example. Account holders with earned income can enjoy a higher contribution limit. So an account holder would be the consumer, the individual with special needs or disability. And I will shortly update these numbers because the annual contribution limit, now that we're in 2025, is 19,000 instead of 18,000. And you can, if you have earned income, you're eligible to contribute up to $14,580 in earned income from, if one has earned income, you can put in an extra 18,000. So with the limit going up to 19,000 this year, and then the added contribution for individuals that basically terminated and from an employer, then they can either transfer a 401k into an ABLE account, or if they do have earned income, they're eligible to contribute at a higher level to the ABLE account, assuming that they do not have a 401k or a retirement plan at work. Okay, so for 2025, it's 19,000 is the maximum amount. Okay. The tax credit for ABLE accounts in Indiana is alive and well, and that of the first $2,500 contributed to an ABLE account. So the on the first 2,500. So as you can see here by the slide, 20% of 2,500 would be $500. And so if in a calendar year someone were to contribute $2,500 to an ABLE account, the state would be able to give them back $500 on their state income tax filing. And so that can be particularly handy, if a parent or grandparent or someone is contributing to an ABLE account on behalf of their family member with special needs. So that's relatively new. That just began in 2024, last year. And so this is a very recent development on ABLE accounts specific to the state of Indiana. So some other states do have either credits or tax deductions, that type of thing. The Indiana 20% tax credit is among the most generous in the nation, certainly. So we want to make a point of that. Okay, we have people joining us as we're moving through. I'm very excited. Okay, so I welcome questions. So anyone that has a question about ABLE accounts as we're moving through this, then please either unmute yourself and let's hear from you, or let's put the question into chat, and I'll be happy to answer it. Okay, so again, details covered so far. Disability prior to the age of 26, and one either is on SSI or anticipates applying for SSI. They're eligible for an ABLE account. ABLE accounts grow tax-free and they distribute tax-free. What does that mean? That means if you were to put $1,000 into an ABLE account and it grew to $2,000, then the $2,000 can be withdrawn for a qualified expense, and it can be done so without taxation or penalty. So that's very exciting. The opportunity to have monies go in, grow without taxation, no 1099, no tax implications at all, and then to make a withdrawal for a qualified disability expense, a QDE, without any tax or penalty whatsoever. Now, one of the advantages of ABLE accounts over 529s is that 529 accounts, of course, are set up to provide for education expenses. You are not limited with ABLE accounts to utilizing funds for education expense. So whereas that limitation exists for 529 accounts, no such limitation exists with ABLE accounts. And with an ABLE account, you can use the funds for any expense for something that benefits the account holder or the individual with special needs. And so that's very exciting. So it's almost unlimited as to the different things that can be spent on. So, so questions come up about ABLE accounts. Do we have a question? Okay.
Gordon, this is Lisa. I just wanted to tell you, sometimes when you're moving, we lose your voice.
Oh, okay. All right. Well, let me come back. Here we go. And let me retether myself. And the reason for moving was to get a cup of tea. I I came back from Australia a couple of days ago, and I still have jet lag. And so the last couple of days, caffeine has been my friend. Okay, and now I'm retethered. Hopefully, we'll no longer have that problem. And so I was getting myself something to that 18-hour time difference is is really something. Oh well. All right. So again, you don't have the limitation with the ABLE account, and you can use the funds for almost anything. In addition to that, if you have funds in a 529 for a child with special needs, and you're not certain, and by the way, there's a broad list of things that ABLE accounts can be spent on. You can see it's quite expansive. It can even be used for legal fees. In fact, if there's money in an ABLE account, it could pay for setting up a special needs trust with an attorney, etc. It could pay for guardianship expenses. So it's very broad as to what you can use monies in an ABLE account to pay for. Okay, if though you have a 529 account for an individual with special needs, and you're thinking, you know, we set up the 529 because we were thinking maybe there would be post-secondary education expense, this type of thing, and there isn't going to be, then the good news is that you can actually transfer funds from a 529 account over to an ABLE account, tax-free and penalty-free. So you heard me right. It's possible to transfer balances in a 529 account over to an ABLE account. So you might say, well, why would I want to do that? It grows tax-free in a 529 account. It distributes tax-free in a 529 account. So what's the advantage? Well, the big difference is that once the funds are in an ABLE account, they can be dispersed for all kinds of expenses and needs. That's not the case with a 529. So if you have funds in a 529, if you can't pull them out for education purposes, you may get a little bruised in the process because any gain is going to be subject to taxation and a 10% penalty. However, if the funds from the 529 are transferred to the ABLE account, then the ability to make withdrawals for a myriad of expenses is there, free of taxation, free of any penalties. At this point, we have the ability to do those rollovers from 529 to ABLE accounts through the end of this current calendar year, which is 2025. And part of the pending legislation is to extend that. I mentioned earlier that there is pending legislation on ABLE accounts, and part of that is to extend out the ability to transfer funds from a 529 to ABLE beyond the end of the current calendar year. Now, you might ask, well, how does that work? And the answer is that you are subject to the annual contribution limit for an ABLE account as to what you can transfer from a 529. So let's say, as an example, you had $50,000 in a 529 account. It might take 2 or 3 years to get that transferred over to an ABLE account because of the annual limitation. Currently, in the current year, $19,000. So that $50,000 would take 3 years basically to get all transferred over to an ABLE account. So that's where you could get 19,000 of it transferred in 2025, the current calendar year. But we're looking very hopeful that that extension will be approved so that we can continue making progress for families in moving funds over from 529 to ABLE accounts so that we have no age limitation and certainly no limitation as to what the funds can be spent on, tax and penalty free. Okay, so let me go to chat and see. I hope these slides are still showing, but I was trying to get over to pick up the chat. Okay. So it says, speaking of guardianship expenses, is there a general range of what it costs to establish guardianship? Does that include everything, or are there miscellaneous fees to budget for? And are there ongoing fees after guardianship is established over age 18 that we should budget for? And this is Angie Burton. So Angie, thank you so much. What a great question. And the answer is legal fees vary by geographic locale. Sometimes in the rural setting, the guardianship fees can be a little less. But I would say the going rate for guardianship in the state of Indiana, there we go, and hopefully this is still showing the slides. But the going rate in the state of Indiana for guardianship is in the $1,250 to $1,750 range. So that's $1,250 to $1,750 would be the range that we typically see. You may find, some nooks and crannies where out there where you can get it done for less, but that would be the most typical range for a fee for guardianship, $1,250 to $1,750. All right, some attorneys will accept a payment plan, do not require full payment up front. That can be particularly helpful if you're applying for SSI as a result of their turning age 18. Therefore, the monthly SSI benefit coming in could enable you to make the monthly payment to the attorney to pay off the fee for guardianship. So over a 12-month period, that monthly amount to the attorney could be anywhere from perhaps $100 to $150 per month. And that, of course, would be a lot easier to stomach if they were receiving an SSI benefit of upwards to $967 per month, especially when the SSI benefit is tax-free, both federal and state. And then the third question, I believe, that was included with that masterfully composed message from Angie Burton is, are there ongoing expenses after guardianship is obtained? And the answer is potentially yes. I think also slipped in there are there any other fees besides the attorney's fees? And that's also a yes. So very good. So there is a fee to the court for court cost, and that fee runs approximately $175. That does not go to the attorney, that goes to the court to help with court costs, etc. So you're looking at an attorney fee of $12.50 to $17.50, and you're looking at court costs of approximately $175. Now, there are some legal clinics or low-cost legal options. And so if one's financial circumstances are challenged, then it may be possible to get you connected with Indiana Legal Services Organization or other free or low-cost legal clinics if you qualify. And we're certainly happy to assist families in getting connected with with those agencies or organizations that could be helpful with guardianship at lesser cost if the financials are there. Then, as far as costs for guardianship going forward after the time of the hearing, then there is a state statute that allows counties to request or require biannual reporting from the guardian on the minor or the ward, the person for whom guardianship has been obtained. And so that varies by county. And you could check in with your county attorney to see if you are one of the counties that expects or looks for every 2-year or biannual reporting from the guardian. Now, in some cases, the attorneys that assist you with the guardianship hearing and guardianship process perform that function every 2 years for you. And there are some attorneys that roll it into the fee. So I know of one attorney, as an example, that charges the $17.50, and you might consider them expensive, except included with the $17.50 is the biannual filing going forward. And if some other attorney is going to charge a couple $100 to do the biannual reporting, and the attorney at $17.50 is going to do that for you indefinitely going forward into the future, then you can see how it kind of weighs out that the attorney charging more may actually be the better value. But do not be overly concerned about these legal fees for guardianship. As I said, in some cases, a payment plan is possible. Also, SSI may be coming in, and on top of that, where available, we may be able to get you connected with a clinic or a organization that can provide legal services at a discounted cost. So tremendous questions. Thank you. Thank you so much. All right. So the ABLE tax treatment, after tax dollars are contributed, so you're putting in dollars that have already been taxed. Indiana state income tax credit is available for up to $500 per year. That would be on a $2,500 calendar year ABLE account contribution. You don't have to put in that much. If one puts in just $1,000, that's a $200 credit available. Tax deferred growth. So ABLE accounts grow tax-free. Withdrawals for qualified disability expenses are tax-free as well. And if guidelines are followed, it does not affect government benefits and programs. So the ABLE account does not count toward the $2,000 resource limit. And so it functions as an accumulation account without it undermining eligibility for benefits. Let's see here. ABLE solves resource issues. So let me give you a few examples about ABLE. If you have a situation where someone gets a part-time job and they want to save their wages, they don't want to fritter it away. They don't want to just keep buying computer games or eating fast food or whatever. They really want to save up some of what they're making. Then they can set up an ABLE account and put any portion of their wages that they want into the ABLE account, accumulate and grow it. And then at some point down the road, when they want a new computer, a new computer game, a new cell phone, they want to go to Disney World, take a Disney cruise, they want to go horseback riding, take a vacation, they want to get some new clothing, equipment, on and on it goes, then the ABLE account is ready and willing to help sponsor these items and pay for them based on what they've accumulated in the ABLE account. So in some situations, it can be an opportunity to instruct them on financial things or help them understand delayed gratification. get excited about their building or accumulating ABLE account as a motivation to keep them working and benefiting from the work experience, etc. Now, I should mention, it's important to mention the item at the bottom here, and that is while ABLE accounts can solve resource issues, meaning that if someone has $3,000 in their savings account and you're thinking, oh my gosh, they're going to lose their SSI, they're going to lose their Medicaid waiver services, etc., then an ABLE account, open an ABLE account, transfer $1,500 into the ABLE account right out of their own account, right out of their own savings or checking account over to the ABLE. Now the government sees them as having only $1,500 and they're under the $2,000 limit. So it is super convenient as an account to deal with otherwise too much in the way of available resources. And then also if they receive a gift or an inheritance. So a grandparent says, for Christmas, for Easter, for whatever, here's $1,000. Well, if they're concerned that $2,000 is going to cause a resource issue, the $1,000 or $2,000 can be placed into an ABLE account. And again, it will not count against them. Also, an unintended inheritance. A grandparent passes away, leaves $5,000 to each of their living grandchildren. Here comes the $5,000, and the parents are like, we can't spend this fast enough. Then set up an ABLE account, throw the $5,000 in there, boom, call it a day, they're good to go. Now, the last item on this page, super important, is that ABLE accounts do not solve income issues. So please do not misunderstand. They can solve resource issues, but when I'm talking income issues, if they have a part-time job or employment, putting their earned income into an ABLE account is not the same as not earning it. So putting money into an ABLE account will not cause Social Security to not recognize the earned income they have received. So I want to make sure you're aware of that. But the good news is there are remedies for almost everything. There's almost no situation there isn't a remedy for, and it's just powerful. It is great. After spending almost 30 years sleeping, and breathing this stuff, we know most of the remedies. And so regardless of the situation one brings to us, I mean, I had a situation earlier today where I was meeting with a client who has a child with special needs, and it was his brother at age 62 that we were concerned about. And that's a situation where knowing government benefits, and at 62, he has money. So how are we going to get help for him? How are we going to avoid a spend down situation where his money just gets frittered away paying for care until he is penniless? And the answer is there are ways to do that. So it's very exciting to have these tools at our disposal to help families. I think there was a question in chat, so let me take a look. Thank you so much for your patience with me here. Okay. Okay, bear with me. I'm going to come back. I've got a couple in chat, then we'll return. Okay. So the first is from Brian, or BRI, Bree, I guess, Bree. Okay, so thanks so much. Can you contribute SSI to an ABLE account or just job earnings? Great question. And the answer is you can contribute to ABLE from wherever the money came from, but you would want to use the funds for its intended purpose. So if you do have SSI, of course, is always for shelter expenses. Used to be food and shelter, and the Social Security has changed that. But nevertheless, Social Security should be reported as having been used for shelter or possibly food and shelter expenses. Once it's reimbursed for those expenses, then it can be used for whatever you want, including putting into an ABLE account, etc. So the answer in a roundabout way is yes, SSI funds can be put into ABLE, but they need to reimburse for living expenses first. Gifts, inheritances, small settlements, all of those are game for putting into an ABLE account. Next is, I have missed if you already covered this, but money left in an ABLE account if the person passes. What happens to it? Is there a beneficiary, or does it go to the estate or the state to pay Medicaid buyback I may be confusing my terms. Okay, so thank you so much, Angie, for weighing in on that question. And it's coming up absolutely within a couple of slides. We will be talking about that. Okay, so all right. This is something that some people know, but not a lot of people know, and that is if one is receiving a reduced benefit from Social Security for SSI, and typically if one is receiving a lesser amount, which for the current calendar year would be $650 or roughly $650, as opposed to the $967, again a $300 difference. Then it may be because the Social Security is classifying the individual as receiving in-kind support and maintenance. This is a term Social Security uses as a reason for reducing the benefit to 2/3 of the maximum. But what you can do if you want is funds can be transferred into an ABLE account, even from a special needs trust. And then if the ABLE account assists with those living expenses, it does not count against them. So any situation where one is receiving a lesser SSI benefit, again, for the current year, approximately $650 for 2025, then we should talk because an ABLE account may enable or help you get your benefit raised up to the 967 for the current year. All right, let me get back here and make sure I'm back in the sharing mode. Here we go, so that you can see the slides. Okay, excellent. Okay, and hopefully they're showing. Okay, all right. So the goal, of course, where SSI is involved is to help families get the benefit for your loved one up to the maximum amount, which for the state of Indiana for the current year, 2025, is now up to $967 from the $943. So it's getting really close to $1,000 per month, but that's if you're receiving the maximum benefit amount. If you're not, let's take a look at the situation and see what we can do to get your Social Security or SSI benefit raised. All right. Okay. Yes, per the earlier chat question, ABLE account do require a Medicaid payback provision. So in the event the account holder passes, the state does reserve the right to step in and seek to reimburse themselves for Medicaid or Medicaid waiver benefits afforded them while they were living. So we have not, that I'm aware of, had a 529 account holder pass thus far. When they do, it will be interesting to see what the state does. But the state does reserve the right, Indiana reserves the right to seek reimbursement for Medicaid benefits afforded them while they were living from the trust. Okay. See here, including third party. Okay. Yeah. So one can certainly list a beneficiary such as parents or others, but it's up to the state whether they step in and seek reimbursement before the remainder of beneficiaries are paid from the account balance. And then as to who can contribute, great question. Parents certainly can, grandparents, siblings, and even the consumer themselves. So the individual with special needs or disability can contribute to their own ABLE account from wages from employment, etc. Okay. All right. Yep. Here we are. Okay. ABLE. Okay. We tried to be there. ABLE programs are developed and managed on the state level. Please keep in mind that for the Indiana ABLE account, which is called InvestABLE, that is the account that will receive the Indiana state income tax credit. So even though an account could be set up in Kentucky or Michigan or somewhere else, Please understand that if one does file an Indiana state income tax return and wants to get the state income tax credit, that's going to come as a result of contributing to an Indiana plan. So you couldn't have a Kentucky plan, as an example, put $2,500 in there and then expect to have a $500 state income tax credit in the state of Indiana. So in order to enjoy the credit, you need to file a return for the state with the state of Indiana, and you need to list the contribution made to ABLE on your state return. The respective state and state plan determines the enrollment process. Enrollment and maintenance of the account is primarily done through the individual state ABLE program. So in Indiana, it's called Direct ABLE. It's been renamed. It was Invest ABLE. Now it's Direct ABLE. And so you're able to go to the website for Direct ABLE and literally set it up online. It takes some 25 to 30 minutes to set up, so it's very quick. In case you're curious, fees are relatively low. I think the annual fee is only a little over $40. Again, the annual fee, only a little over $40. The mutual funds that are used are no load funds. So you have very low fund expenses and charges, and they're no load to begin with. And the annual fee is only a little over $40. So these are really inexpensive programs to have. The National Resource Center, the National Resource, there we are. National Resource Center is a national clearinghouse for information on ABLE accounts. And so if you go to www.able.nrc for nationalresourcecenter.org, then it calls information on all ABLE account plans across the country. And you can compare one against another, etc. Okay, so for Indiana, again, it's just changed literally in the last week or so to Direct ABLE. But nevertheless, we have the Indiana plan, and then in Kentucky, they call it the stable account. So you'd think Kentucky had something to do with horses, a little tongue-in-cheek there. But nevertheless, each of these states have ABLE account plans, and they're available to establish online. All right, we have another question. Give me just one moment to get over the question. We're doing awesome. Okay. And we bring up the question, and here we go. Come on, computer, you can do it. There we go. And the question. Okay. Question is, can you go through Edward Jones or any other broker to set up an ABLE account? Would they be more up on the laws over the average parent? And the answer is yes, you can set up an ABLE account through a broker. You are more likely in that case to get a non-Indiana account, and that's because the Direct ABLE for the state of Indiana is a self-help plan, meaning you would be educated by someone like myself. You would go online to set up the plan, and the website gives you information about ABLE accounts to read, etc. So broker setup ABLEs are most often utilizing American funds. American funds are a wonderful fund family. It's the Virginia plan, the ABLE America plan through Virginia, and it's a great plan. However, it is not no load, and it is not going to have the state income tax credit. So at this point, if you're starting from scratch, so the exception would be where you have a 529 account that's with American funds, because American funds 529 account for Virginia is one of the most popular 529 accounts in the country. And so if you have a 529 account with American funds already, and you're wanting to do a rollover of funds from the 529 to an ABLE account, then it may work very well to stick with American funds on that, because you would not be subjected to that the load on the transfer from the 529 over to the ABLE account. So if you have a 529 already with American funds, consider switching it to ABLE also with American funds. If you're starting a new ABLE account, I would encourage you to consider the Indiana, direct Indiana ABLE account, since it includes the state income tax credit. So I hope that is helpful, but I'm happy to answer additional questions. And please allow me to remind you that we're providing a free follow-up consultation so we can drill deeper into ABLE accounts or questions that you have as a result of this evening's discussion. Okay, great questions. Okay, and Lisa is putting a link into the chat. All right, fantastic. Thank you, thank you, thank you. Let's see here. Okay, we're bringing the PowerPoint back up. Okay, so hopefully we're still in a share mode. At least I hope we are. Okay. Kentucky has a plan as well, but I would imagine most of you are residents of the state of Indiana. There's also a card, a debit card that you can get with the Indiana ABLE account. And that gives easy access to funds that are in the ABLE account to go about spending on things that benefit the consumer with special needs. Okay, so this is where an ABLE may help and where it may not. So the next couple of slides may be particularly helpful. And we are on track to be wrapped up by 7:30. So have no fear, we will not run long this evening. Again, we've got about 10 minutes to go, depending upon how many questions come in. So an ABLE account may not be the best vehicle if inheritances, settlement, judgments, or contributions from family or beneficiaries exceed the maximum contribution limit, now $19,000. So if we're dealing with an amount greater than 19,000, ABLE may not be the best choice because of that annual contribution limit. Contributions are not coming from the individual with a disability and therefore could go to a third-party special needs trust, avoiding the Medicaid payback associated with an ABLE account. Although I did promise to talk a little bit about special needs trusts, so we'll probably round out our 90 minutes with some talk about special needs trust. I don't want to disappoint anyone. Beneficiaries with disabilities that whose origin came after the 46th birthday. So if it's something that's onset later in life, then they're not going to be eligible for an ABLE account. Currently, it's age 26. As of January 1st of next year, it becomes age 46. But if the disability is as a result of a stroke at age 50, a fall down the steps at age 48, I think you see what I'm saying. If it's beyond 46, ABLE is not going to be eligible. The beneficiary cannot make financial decisions, and there is no guardian. So if there's no one in charge, it may be difficult to get an ABLE account up and going. ABLE accounts can be used in combination with other vehicles, such as special needs trusts. All right, so with the Medicaid payback, we're suggesting that you consider it to be a put and take or a save and spend type of account, meaning not some place to amass hundreds of thousands of dollars, but instead a place of convenience to set aside smaller amounts of funds. So we have a few examples here to share with you. Example one, a grandparent dies and leaves $10,000 directly to each grandchild. For the grandchild with special needs, it must be spent, used to prepay final expenses, or could be deposited into an ABLE account. Number two, a school bus incident. At school, so the story here is this was not in Vigo County, fortunately, but somewhere in the state of Indiana. It was a disability school bus, a short bus, and the aide that normally traveled on the bus was out, and so a replacement was recruited to run with the bus, and they were not, I guess, as well trained as they should have been, or not as careful. And so a young gal with special needs, wheelchair bound, was on the school bus, was not appropriately restrained. They arrived at the school, the door swung open, and she rolled out of the school bus and face planted on the asphalt. By the grace of God, she did not have facial fractures, just abrasions, scrapes, and this type of thing. And so the school corporation and the family arrived at a settlement for the situation, which turned out to be $15,000. The child was on a Medicaid waiver, the health and wellness waiver, and so it would have caused a big problem for continued eligibility for Medicaid waiver services. So the $15,000 settlement was placed into an ABLE account. Benefits were retained for the child, and the $15,000 then became available to be used over time to help with her needs. Example number 3, an individual with special needs gets a job resulting in earned income. They want to save some of it for a vacation, furniture, or additional schooling or vehicle. So while maintaining SSI, so they know it can't sit in their checking or savings account. Let's see here, while maintaining SSI, so Medicaid, Medicaid waiver, etc. An ABLE account allows the funds to accumulate for future use without being subject to the $2,000 resource limit. Okay, so some examples where ABLE saves the day. ABLE accounts within limitations can address resource issues by sweeping the inheritance, legal settlement, paycheck 529 by rollover, savings or investment account into an ABLE account to get the consumer back under the $2,000. An example of this would be consumer age 22 is receiving SSI and has a part-time job earning $500 a month. Placing his or her $500 paycheck in an ABLE account or the employer ding the same will not allow him or her to avoid the reduction in SSI. So it does not resolve income issues. However, the ABLE account will keep his bank or savings under the $2,000 for benefit eligibility. So again, it solves the resource issue. Another example, a consumer age 35 receiving $500 a month in SSDI, Social Security Disability, from their own record of employment. They also receive an adult child benefit of $1,200 from a parent's record. They continue to work earning $1,100. So you can get into a situation where their income is too much, and your ABLE accounts do not solve income issues. So we're just referencing, in this case, the potential need for a Miller trust. If in total income between Social Security earned and unearned income gets north of, for the current year, it's now $2,900. The 2829 is now $2,900. So if you're north of $2,900, we may need to look at possibly MedWorks, which is an option we talked about in an earlier workshop, or a Miller trust. But there are remedies for having too much income to maintain benefits as well. Okay, ABLE accounts within limitations can address resource issues. Oh wait, we're already there. Boom, 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 boom. Okay. Another tool may be a special needs trust. So here, I promised to get to trust, and here we go. Special needs trust stipulates how money is contributed to the trust or dispersed for the beneficiary. State-specific language. So we use special needs trust a lot here in the state of Indiana. It is a wonderful thing. They are inexpensive, and a special needs trust can be set up. It can be funded by a small amount of money. It can be funded by a large amount. It does not have to be funded at all. It can remain dry until parents die and they leave money to the trust. So it's very flexible. But special needs trust is a miracle in the special needs community because you set that up and parents or families can gift to and leave an unlimited, can gift to or leave an unlimited amount of money to a special needs trust to help preserve quality of life for your loved one with special needs. It is so very cool. The trust names a trustee who is responsible to carry out the terms of the trust agreement. It says the trustee is obligated to act in accordance with the trust provisions, this type of thing, and there are several types of special needs trusts. So special needs trusts, I'm an advocate of special needs trusts. I think they're great. We have a, okay, so Lisa has responded with, I can make it available. Okay. Get out of this. Okay, here we go. Boom. Okay, cool. Alrighty. Let's get back to the PowerPoint. Or we're going to try to get back to the PowerPoint. There we go. Okay, hopefully we're still sharing. Again, there are different types of special needs trusts. There are special needs trusts that can be set up to offload a person's own money in order to be Medicaid eligible and preserve their resources for future use. There are special needs trusts that parents can set up and leave money to, life insurance funds or leftover retirement funds and so forth. There are Miller trusts when income becomes an issue. So there are lots of opportunities to use the different types of special needs trusts to solve these planning issues. Okay. So overall, from a planning perspective, it's important to work with individuals that are experts in their field. Special needs planning is complicated. There's a lot to know. I would encourage you to take advantage of the free follow-up consultation that we're making available to participants, that type of thing. I know at least one, or maybe there were a couple that perhaps had a question or had or questions on special needs trusts. Would it be possible to put a question into the chat? If so, I would be delighted to answer any questions on special needs trusts. We do have attorneys that we work with that will assist in setting up a special needs trust. Very reasonable, with payment plans available. So most any family can get a special needs trust set up. There are also pool trusts, like with the Arc of Indiana. We can make a referral to the Arc of Indiana Pool Trust as an option. Melissa Justice and her people down there do a great job. But the key is for you to know that there are options, and it's a matter of finding the best match for your situation as to what option we want to pursue. This is my contact information if anyone wants to take a quick snapshot of that. I have, as I mentioned before, an office in Louisville on Corporate Campus Drive, and then the office in Indianapolis, just east of Meridian Street at 96th. Okay. All right. I'm going to come out of sharing because that completes the PowerPoint presentation, and we're right on time. We're doing absolutely awesome, and I'm so thankful for everyone. Let me, let's see here. Let me get back into, let me get that off the screen. Those are trust accounts that I'm in the process of working on. And let me, get to this and see if there are any questions in chat. I do see one. It's okay. It says, thank you very much for the information. Okay. We covered a lot, even though the topics were, you might consider as fairly basic between guardianship and ABLE accounts. There's so many changes with ABLE accounts that have made them more valuable and helpful, and with the state income tax credit, et cetera. And then with guardianship, the wonderful question Angie Burton asked about fees and charges and how all of that works. So we're better by working together and having you all participate with questions and that type of thing. As we run down here on time, if there are any additional questions, I'm more than happy to answer them. I do want to encourage you again to take advantage of the free follow-up consultation. And then Lisa, help me out. I know this was a series. Where are we at in terms of the series and future opportunities?
We have one more left. It's on February the 13th at 6, and it's on life care planning. So if you haven't registered for that, please do. We'd love to see you back here to talk with Gordon again.
Okay, all right. And my apologies for my bit of jet lag this evening. Uh, yeah, it was the trip of a lifetime, and very thankful that um, very thankful that we were able to go do that. But there's an 18-hour time difference, and so every night I wake up at 2 in the morning, and this body is not 29. So we're trying to get reacclimated to being back here in the wonderful state of Indiana that's getting warmer, by the way. It's getting warmer.
Gordon, you've
So,
got a new question.
okay, all right, let's take a look. I'm so thankful for everyone. You all are such a great group and so appreciative of your questions. At what age should we set up a trust for special needs child? My daughter is 16 now, and my answer is there's no time like the present. If we all knew the timing of our departure, we could all do our planning in the few days before we leave, but we just don't know the time. And a lack of planning really creates challenging circumstances for families to deal with. So I would say sooner versus later, but at a minimum, take advantage of the free consultation so that we can talk about the unique aspects of your situation. Let's see, someone has added, okay, thank you. I wasn't sure if she had to be 18, and the answer is no. In fact, I will tell you, the youngest I have set up a special needs trust for is a newborn, had a newborn with Down syndrome in New Albany. And literally the hospital social worker gave them my information while the child was, the infant, the newborn was still in the PICU. Or not PICU, it would be neonatal, I guess would be the right term. Get it right. PICU is what my son was in for 3.5 months. That's why it stuck with me. But nevertheless, they reached out to me and we started the process while the child was literally still a newborn. So from birth to grave, we serve it all. But earlier is better typically. And so I so admire and thank all of you for taking your time. We're all so busy chasing our tails. For you to take time to share with us this evening and the questions you've asked, etc. And of course, for Lisa, bless her heart, all the good works that she does and helping make this series possible. So we got one more. What was the date one more time, Lisa?
February 13th on life care planning.
Great. And that pulls all the elements together. So what's really powerful about life care planning is we've talked about all these different things. It's only natural to think, how does all this come together? And so life care planning is designed to put the pieces into place in a cohesive plan. And how does that work? So really excited about that upcoming session. You might call that kind of advanced planning. Very cool. And so please get that on your calendar, register as appropriate, join us, please. And I look forward to meeting with many of you individually. Let's see, one last thing from Angie here. Let's see, is there a link to sign up for February 13th, Lisa?
There is. Angie, I'm going to be sending out an email tomorrow to all of you that will have the evaluation link for today. And I will put that link in it as well so that you can get to the registration page. In addition, I can go ahead and add a link to this video off of our YouTube channel. It'll be private to just the folks who registered. But I would encourage you to take advantage of Gordon's offer to have a free consultation because you're going to learn more from that than reviewing the video, I think.
All right, guys, so thankful for you. Stay safe, stay warm. Look forward to seeing you soon. Take care.
Okay. Thank you, everyone. Have a good evening.